cruelty, that you find that in fact there was cruelty. Quite frankly, if you compare what Detective Flores testified to what was presented here, you will find that actually it's much more vivid, much more horrific, and in fact perhaps there's even a little bit more of the F6 factor. It could be a little bit heinous by the defendant's own definition, because it does appear that she shot the body of Travis Alexander after he was dead. So there is no due process violation here. There is no authority that is cited for you. There are cases that are read from, and there are cases that defendant alludes to, but none of those cases deal with the situation that we have here. All of those cases deal with granting a new trial. Well, that's not the position that we're at here. We're talking about a much lesser standard. We're talking about a preponderance of the evidence standard. We're not talking a beyond a reasonable doubt standard. And for example, the case that he talked about, the police being an arm of the prosecution, that's true with regard to discovery, but it isn't true with regard to what an officer says on the witness stand. So these cases can be differentiated. And bottom line, what it comes down to is a detective who spoke to a doctor the day before the Cronus hearing and heard about suffering. That was the extent of what they really talked about. And then based on what he thought he heard, he came in. A misunderstanding is what he said. And he took responsibility. He said, it was me that did that. And I'm the one that created that issue. To say that the defendant has been harmed, quite frankly, it's just not the state of the case. The defendant actually has been helped, because now there's an issue for the jury to consider as to whether or not Detective Flores has been fair. It is something that has helped them, not hurt them. So I would ask that you deny the defendant's request. Whatever it is that he's requesting, if it is that for a mistrial, I ask that you deny that. If he's asking for a new determination of probable cause, I ask that you not provide that to them, because I think they rested on their laurels. But if you're inclined to do that, there's no doubt that there's probable cause here, and that Travis Alexander suffered, and that he was in physical and anguish, and mental anguish, and the defendant knew about it because she killed him 3 different ways, and he had defensive wounds. So therefore, I ask that you deny the relief that they're asking.
Mr. Nurmi, anything further?
I do, Your Honor. It appears, counsel for the state, it often seems every time an issue comes up of prosecutorial misconduct or anything of perjured or mistaken testimony, he says, hey, this is really a motion for reconsideration. And he mischaracterizes the defense argument and says it's a motion for reconsideration. And that's not the argument we're making here. One thing that counsel for the state did not do is he did not even discuss the idea that there was perjured testimony, because he said, it came out today, whose opinion was it? Mine. That came out a couple times. Emphasized in front of the jury, Detective Flores said it was his opinion. The Cronus transcript is pretty clear that he said it was Dr. Horn's opinion. All right. Counsel for the state, in mischaracterizing the defendant's argument, says, they knew about it for a year. They're admitting that fact. I said, yeah, when we interviewed Dr. Horn, we knew that was his current position. We did not know that it would not shift, because apparently the facts in this case are shifting from the state's perspective. And now we have a situation in which, now that he's given sworn testimony, obviously this wasn't a deposition, he wasn't sworn, this was an interview. Okay? So it's a lot different. The other thing I would point out to the court is I would point out to the court, because the state seems to believe that there's something nefarious in not bringing these issues up, I would point the court's attention to State v. Marshall 197, Arizona 496. It deals specifically with the fact that defense counsel is not obligated to point out the weaknesses in the state's case in advance of the case, and can raise those issues when they feel it is appropriate. The final argument, I think, is that Ms. Arias should be thankful to the state for changing their stories because it's placed her in a better position. However, as we said, we do not share that opinion. Given this, first of all, it could not be relitigated. It is raised judicata. The only issue at any Cronus hearing would be the cruelty based on this news story. The state has not heard all the evidence because Ms. Arias, now that we have this sworn testimony, now that we've heard, and we, quite frankly, we heard some different things out of Dr. Horn than we heard during the interview in this testimony, we should have a right to go back, declare a mistrial, have another Cronus hearing at a certain point in time when Ms. Arias has the opportunity to have a medical expert of her own go forward and offer their opinion as to the sequencing of the injuries and how that relates to the prong of cruelty, based on what Dr. Horn said in court. Because if we had done this based on an interview, there would still be wiggle room, and we see that wiggle room is important in this case. We don't want to leave any wiggle room. We now have sworn testimony that contradicts the Cronus hearing. We have a detective who tells us that it was based on his opinion, not Dr. Horn's opinion. And a determination of probable cause on an aggravator cannot rest on, given the scrutiny of the death penalty, cannot rest on the opinion, the medical opinion of a detective.
All right. The court has considered the testimony of Dr. Horn at this trial, the testimony of Detective Flores at this trial. I have also reviewed the ruling by Judge Duncan on August 18, 2009 regarding the aggravating factor of especially cruel. I have reviewed Cronus versus Steinley 208 P3rd 210. I have reviewed Rule 5, Rule 16, and Rule 13.5C of the Arizona Rules of Criminal Procedure. The court finds that the motion for a new finding of probable cause on the aggravator is not timely made under Rule 16 or under Rule 5 of the Arizona Rules of Criminal Procedure. However, even if the motion had been timely made, the court finds that the testimony of Detective Flores would not have changed Judge Duncan's rulings with regard to the aggravator of especially cruel. In her ruling, Judge Duncan stated, a first-degree murder is especially cruel if the victim suffers physical pain or mental anguish and the defendant knew or should have known the victim would suffer. To establish this aggravating factor, the state does not need to prove that the victim was conscious for each and every wound inflicted, and she cites pertinent law. Physical pain may be found where a conscious victim physically suffered for at least a short period of time. She then makes factual findings. She does find that the state presented evidence the victim was first shot on the right side of his head near his eye with a .25 caliber handgun, and that the bullet lodged in his left cheek. This wound was not fatal and may or may not have rendered the victim unconscious. The victim did not remain unconscious based on the infliction of other wounds and the location of blood spatter evidence in the bathroom sink and blood in the hallway. In addition, the defendant told the police that the victim was unconscious after being shot, but then crawled around and was stabbed. The victim was stabbed 27 times in the back, shoulders, head, and chest. Cuts on the hands were defensive wounds from grabbing the knife. With the exception of 2 wounds, these wounds were not fatal. The 2 fatal wounds were a deep stab wound to the chest and then a cut across the throat. While unconscious, the victim would have felt pain and mental anguish associated with these multiple wounds. The court finds the state has proved that there is probable cause to believe that the offense was especially cruel under the theory that it involved both physical and mental suffering of the victim. So based upon my reading of this ruling, the testimony regarding the sequencing of the wounds would not have changed Judge Duncan's finding that there was probable cause that this offense was especially cruel, under the theory that it involved both physical and mental suffering of the victim. Even if this court is wrong with regard to that determination, I believe that based upon this court's understanding of the testimony as presented by Dr. Horn at this trial, that there is probable cause to believe that this offense was especially cruel under the theory that it did involve both physical and mental suffering of the victim. So the motion for mistrial is denied. The motion for a new finding of probable cause on the aggravators is denied. All right, is there anything else?
A moment, Your Honor.
I also want to put on the record that there is also a case, Pitts v. Adams, 179, Pitts, P-I-T-T-S versus Adams, 179, Arizona 108, 876 P. 2nd, 1143. It is a 1994 case in which the Supreme Court found that any error in the presentation of evidence to the grand jury was harmless in light of the other evidence presented. I find that case does apply to the facts here in light of Judge Duncan's rulings back in 2009.
And Judge, that was 876 P2B what?
876 P. 2nd, 1143.
Judge, we would ask initially, we had marked but not admitted into exhibits, or into evidence, excuse me, exhibits 289 and 288. We would ask that they be marked and entered as part of the record as it relates to this motion only.
Any objection?
No objection if they're only admitted for the purposes of this hearing.
All right, exhibits 289, and did you say 288, Mr. Nurmi?
288 and 289.
Are admitted for purposes of this hearing only. Correct. They want to go to the jury, so they should be just like